Welcome everyone to the Ask the Expert session on Maputo Protocol. I'm Lara Danani and I'm a legal intern at SAHR. SAHR is a peer-led network of women and underrepresented civil society leaders, and our mission is to resource each other with the skills to use and shape policy to end sexual and gender-based violence. So we're holding this workshop so there can be a peer-to-peer exchange, so we as peers can help each other out and to learn how to leverage to use the law as a tool effectively to handle issues in our communities. And in the event that you need more one-on-one brainstorming following this workshop on your case or issue, we have opportunities to do so after the workshop, so we can just communicate after. And today we have two experts with us, Isabella and Valentine. Isabella is a dedicated feminist and human rights advocate with over 7 years of experience, and she focuses on the rights of children and women. And she's deeply passionate about the power of law and policy in driving sustainable development and achieving gender equality. Currently, she leads the Women's Voices and Leadership Project, aiming to articulate the lived experiences of women by strengthening institutions and human capacity and utilizing legal frameworks to secure women's rights. And we also have Valentine with us, and she's a dynamic feminist lawyer at the forefront of strategic litigation within the Kenya Legal and Ethical Issues Network on HIV and AIDS. And as an advocate of the High Court of Kenya and a network lawyer for the Feminist Litigation Network of the Initiative for Strategic Litigation in Africa, Valentine dedicates herself to researching and spearheading strategic litigation initiatives that drive social change. So today, the objective of this space, the Maputo Protocol is a significant milestone in advancing the rights of women and girls across Africa, and the workshop aims to equip participants with the knowledge, skills, and tools necessary to effectively leverage the protocol in your work. So today we have an Ask an Expert session where you can seek guidance on how you can integrate the protocol into your advocacy work. So the agenda is one, we will have a presentation where we will have an overview of the key provisions in the Maputo Protocol. We can go over some case studies on successful implementation and advocacy. And at the end, we'll have an Ask the Expert Q&A, and we can discuss your case and advocacy efforts. If you would like to directly ask Isabella or Valentine a question, you may do so, but just limit it to 2 minutes. And alternatively, you can write it in the chat. And I just want to advise that when you do ask the question, give us some context, tell us where you're stuck and what you need to do to resolve the problem, and then pose that as a question. We are short on time, so just keep it as short and sweet as possible, and do not mention the victims' names. And if you require more help following this workshop, we can arrange for a one-on-one session together to work together on any further issues. So Isabella and Valentine, if you'd like to start the presentation.
Thank you very much, Lara. Good afternoon, Ms. Njogu. Lara, do you want to project for me, please?
Yes, perfect. I will do that now.
Okay. So as she's projecting, good afternoon, everyone else who has joined us, and we are glad that you've gotten time to come and listen to Ms. Njogu and I. The session, we are hoping that it is going to be concise on what the Maputo Protocol entails and why it's a tool that professionals in the space of human rights should be utilizing it more often. So the presentation is in threefold. I will just do a brief overview of what the Maputo is, some of the articles within the Maputo Protocol, distinguishing element as to why Maputo Protocol is actually lauded as one of the most progressive laws in globally, and then just mention a few case laws across Africa that have been able to utilize Maputo Protocol. And then lastly, a few resolutions and way forward. And then we'll get into the Q&A question where Nyokabi will take over that session. All right, Lara, we are ready for the projection.
Yes. Can you see it or? Okay, perfect.
So next slide. So
Yes.
this is an instrument that was ratified 20 years ago. In fact, the celebration was done in Nairobi in July this year, where Nairobi hosted different actors just to come and discuss where we are at 20 years later. And so we saw it befitting to also have this conversation as to what it truly means to have this instrument from a legal perspective, a professional perspective, and how its utilization is important to us. So it has been lauded as a very progressive tool in terms of safeguarding the rights of women, specifically in Africa, but it has also been borrowed in other human rights bodies, and it covers the whole spectrum of political rights, social economic rights, um, and cultural rights, as well as the environment. And to date, we have 44 countries that have ratified the protocol. One of the things that has made this instrument, next slide, Lara, that has made this instrument quite progressive is one, for a very long time, we have been using what we call SIDO. It's what most of us are familiar with. It's where we have borrowed or done our aspirations from. But what people notice is that despite having SIDO, a lot of the situation within Africa was not changing. And so this instrument was actually informed by one, Maputo recognizes the African cultural context in two folds. One, it does recognize the positive African context in which we practice our norms and cultural aspect, and it equally and in equal measure prohibits elements within the cultural aspect that are harmful elements that continue to regress attainment of rights or gender disparity. Secondly, Maputo is the first legal instrument to specifically talk about violence against women. Most of the protocols are not that articulate and that specific in their wording. And it also went on further to talk about the state having an obligation towards violence that happens within private spaces. And this was important to us because knowing the context of violence, often than not, especially intimate partner violence, or even just violence that occurs to women, rape, defilement. It's not a violation that is done in open space. And this is where a lot of states would then come out and say, but it was something that was done in private. But this particular instrument is very clear that the state has an obligation to look into violations both in public and private spaces. And then lastly, it is a framing of Article 14 that is quite interesting. In all the other legal instruments, when compared to, the Maputo is one that is very articulate. And this is specifically because it just not talks about sexual and reproductive health as an umbrella term. It went on ahead to just specifically single out the issue of medical abortion in circumstances that are befitting or outlined depending on the domestic law. And this is the same provision that I must point out is also quite controversial, or rather has brought out a lot of controversy within Africa. But we have seen different states being able to take this particular article and framing it within their context and making the right to safe and access to safe abortion a reality in countries such as Rwanda. So these are the three, and then there's also the mentioning of women living with HIV, which is not also articulated in a lot of international legal instrument, but the Maputo went out ahead to just specifically single out that they're also cognizant of women living with HIV who might be undergoing some form of violence. Next slide. So in terms of analyzing how the Maputo looks like, these are some of the articles that are in the instrument. So we have articles under economic and social welfare. We have articles around related to marriage, where we have also Article 7D that talks about matrimonial distribution of matrimonial property. We have article on health and reproductive health rights, protection from violence, including FGM, participation in the political and decision-making space, right to peace and protection, and then specially protected women, which has been articulated in Article 20, 21, 22, 23, and 2. And then the issue of equality and non-discrimination is actually a running theme to each of these articles. So that is the overarching aspect, that it is premised on the fact that violence against women is actually discrimination. So the last article is actually the running theme in all the articles. Next presentation. Next slide. So Maputo Protocol has been very useful in terms of, one, being able to guide states across the 55 countries on development of legal frameworks with a human rights perspective, and not just human rights, but also respecting and recognizing women's rights. It has also gone on to support us a lot of courts within the domestic as well as regional in coming up with progressive jurisprudence that can be applied across the continent. It has also supported in the collaboration and development of state and non-state actors' guidelines on accountability, where now states are able to, where individuals of states in Africa are able to take their states into account in the failure of setting in mechanisms or providing them opportunity to claim their rights. It has also been very useful in development of general comments, and the purpose of general comments, albeit them being soft law, they have actually been very useful in being able to articulate how women's rights can be claimed, what that looks like. They've just been able to unpack what it means to be able to accord a woman or young women in this continent their rights. And then lastly, it has been a very informative tool in terms of building knowledge for lawyers and other judicial officers on what it entails to ensure that women are able to claim their rights. Next slide. So I'll just provide an overview of some of the cases that have been able to utilize Maputo Protocol. I'll start with a case in Ghana. This is actually a quite recent case where the High Court in Ghana, specifically the human rights, was able to listen to a matter that was presented by the Commission on Human Rights and Administrative Justice that entailed two women who were fired by the Ghana National Fire Service because they got pregnant. And prior to them getting pregnant, they had served for 3 years as women who served the Ghana National Fire Service. And so from this matter, they were able to demonstrate to court how this is discrimination in and of itself, in terms of why are women being fired for being able to claim and demonstrate their right of being able to start and plan a family. And then secondly, just being denied an economic right that has also been articulated in the Maputo. And in this, it's very clear that the judge did note that, following that it appears that for the first time, the issue of discrimination on the ground of gender has come up for determination by this Human Rights Division of the High Court. Accordingly, resort to international human rights jurisprudence and that other domestic jurisdiction will be necessary and helpful in the circumstance. And if you go ahead and read this whole particular judgment, you're going to know that there was a lot of mention in regards to the role that Maputo played in them coming to the ruling that, or the judgment that they arrived at, which was in favor of the two women. And further to that, the court also ordered that the two women, other than being reinstated, that they are each awarded 50,000 cedis at the time of the ruling. So this is some of the jurisprudence that we are seeing within the domestic context of how the protocol is useful. We also have a very famous case which is called Dorothy Njimanze from Nigeria that was taken to the ECOWAS Court of Justice. This was specifically on matters around sex and gender-based violence, where Dorothy and others were actually picked in the year 2017. They were abducted, assaulted physically and verbally, and between the year January 2011 and March 2013, different state actors they were oscillated between different state actors on grounds that they were sex workers. And this is a matter that went on for quite a while, just being able to establish what that entails. How did the state agencies even arrive to the fact that these were sex workers? And it's a very interesting case because these are not unique circumstances. A lot of women within the region have found themselves in the same peculiar circumstances, to the point where in the process of you trying to claim your right, there's violation that continues to happen, because Dorothy and the 6 others were actually sexually violated while in custody of government agencies. And because of this, the ECOWAS court found that there were a range of human rights violation on the part that Nigeria as a country had committed, and they were awarded monetary as well as the declaratory reliefs. And the interesting thing about this particular case, what was quite interesting is these cases started introducing something that that is called transformative remedies. We know that often there are always remedies that we seek for our clients, usually monetary in nature. But this case, when you read about it, other than just asking for the money, they went on ahead to ask for transformative remedies, which include being able to touch into the structural and systemic barriers that continue to embed or continue to exacerbate gender-based violence. And so they went on ahead to ask for the state to ensure they are training their police officers, the state to ensure that the attitude of police officers and other judicial bodies is changed due to the training. They also went on to ask for law reforms that have a gender lens. And so it's a very interesting case, and I would urge you all to go and read at the judgment, which would be very useful even for lawyers, especially in drafting of some of our pleadings and submissions. Then we have the Cameroon case, where it was a minor was violated, or rather raped, defiled by a businessman. And they underwent the usual process. Go, check the evidence. Medical examination was done. And then this matter, unfortunately, was dismissed on the grounds that the magistrate believed that the case lacked sufficient evidence. And for over a year plus, TFA, through the council, were unsuccessful in obtaining a written copy of the decision so they can appeal. And so what TFA did is that they took this matter to a regional body, which is the African Committee on Experts on the Rights of Welfare of Children, in 2018. And they were able to look at this matter, and they did state that Cameroon had, as a country, failed in terms of its due diligence to ensure that survivors, or rather victims of gender-based violence, are able to claim their, to seek justice, as well as claim their rights and remedies in these particular instances. And so this is actually a very good case when it comes to looking into what due diligence is or looks like within the African context. When you're talking about the prevention, protection, seeking effective remedies, what that looks like, this particular case was able to highlight that. Then we have Kenya, where we have an organization known as CRU, the Center for Rights Education and Awareness. For years, they have been trying to seek guidance from the courts on the interpretation of what the implementation of 2/3 means, specifically whether it should be attained immediately or progressively. And in the year 2017, the High Court issued a declaration that the National Assembly as well as the Senate had failed their constitutional obligation in attaining, or rather being able to adhere to what the Constitution talks about in terms of the principles of not more than 2/3. And in their judgment, they actually mentioned that they were guided by the amicus that was done by the Kenya Human Rights Commission, which invoked Kenya's international obligation to equality in political representation, as it is entrenched in Article 9(1)(a) of the Maputo Protocol. This particular case actually saw it going all the way to the Supreme Court, where the Chief Justice then was able to advise the president then, who was Uhuru Kenyatta, to dissolve parliament for grounds of unconstitutionality. But of course, that never happened. But it's a good case nonetheless in terms of how can you be able to inject or infuse articles of the provision to be able to ensure that the state is being able to implement as per what they had alluded to. We also have another case where that was done by Koval, yet another Kenyan case, and 11 others versus Attorney General and 5 others. This was a matter in regards to the 2007-2008 post-election violence. This is one of those cases that took forever within the Kenyan jurisdiction, to a point where by the time action was being taken, it's because this had been mentioned severally at the African Commission on the state's failure to look into the claims of sexual violence that took place between 2007 and 2008. And the High Court of Kenya in December 2020 held that the sexual violence was an infringement on the right to life under Article 4 of the Maputo Protocol, and victims were awarded monetary, as well as they were awarded a monetary compensation. However, the government is yet to effect it. But the thing about this particular case is people is being able to connect violence against women, despite what year they took place. It's being able to demonstrate that these matters can then be picked and taken to regional bodies for further deliberation, and also for them to hold the state accountable, which is what the African Commission did. And they also got their locus by the fact that Kenya is a signatory to the SAHR Protocol, and as such, they should be able to articulate and also implement some of those provisions. So those are some of the laws that I decided to pick out, but there are very many other laws, jurisprudence that is out there within the globe that you can be able to pick up and utilize even within our domestic, those who are doing domestic litigation as well as regional. Another thing that the Maputo Protocol has been able to do is through the African Commission, which one of its mandate is interpretation of the Maputo Protocol, as well as seeking for accountability within states. They've been able to do resolutions. These resolutions are soft law as well, but they are paramount in terms of when states are being held accountable, or when you're trying to hold your state accountable. These resolutions come in very handy in unpacking what that means, especially because the resolutions are done per thematic issues. So we have a resolution on the right to women's right to land and productive resources. This is under Resolution 262. We have one on the right to a remedy and reparations for women and girls of victims of sexual violence. And we have the most recent one, which is actually the the Nairobi Declaration on Remedies. So I would urge you, as you look up this one, you also look up the most recent one is the Nairobi Declaration on Remedies. And then we have the African Commission Resolution 110 on health and reproductive rights of women in Africa. And then we also have one that is Resolution 292 that just looked at the human rights situation within the region. And then lastly, we have the right to redress for victims of torture and other punishment, cruel, inhumane, and degrading treatment. This was a general comment that was done in that regard. So these are usually helpful even in being able to provide for us context in terms when we are doing our pleadings, our submissions, or even just trying to discuss the rights and how we can be able to claim the said rights. Then what we have learned from the Maputo Protocol is that this protocol has shaped the conversation in Africa when it comes to women's rights. We now have a framework that guides most states in being able to discuss what and how women's rights look like and how they can be claimed. And then the protocol has also largely been very useful in terms of supporting states to develop their laws and policies. So we have seen a lot of states, especially those that have ratified, being able to pick or align their domestic laws based on the Maputo Protocol. However, I must also point out that for states that are dualists, of course, there's a whole process that goes on, and sometimes the language and the aspiration of this protocol might be lost in the process. And then we have seen women individually or as a group being able to go and claim their rights as within their domestic as well as regional human rights bodies, such as the ones I've just outlined, some of the case laws. And then the AU has developed a scorecard for the implementation of the protocol, which is something as an organization we are keenly following to see how this works, which countries are utilizing which particular sectors of the law, and this is how we're also able to know that one of the most contested article is Article 14 across the continent, because of the scorecard. And then lastly, its states are now able to take this to be held accountable by human rights bodies as well as individuals when it comes to claiming their rights. And so in terms of moving forward, there is a campaign within the region in terms of pushing for ratification for the 11 countries that are yet to ratify it. There is definitely a need for more awareness on the protocol. It's interesting to see even some judicial officers are more familiar with CEDAW than they are with this regional protocol. And so there must be deliberate and intentional effort to create more awareness on the protocol. And then we have the domestic premise. They are trying to align with what is in the protocol. And then lastly, there is need to establish formidable or follow up on what already exists in terms of monitoring mechanisms for the protocol, be it by the laws that are being set, be it the jurisprudence, and also having a keen interest on how the intersectionality is being brought out in these laws, as well as jurisprudence that is coming out through the utilization of the Maputo Protocol. That is the end of my presentation. Thank you very much.
Thank you, Isabella, for the presentation on Maputo Protocol. We have some questions in the chat. Are you able to view the questions?
No.
Okay, I will read them out to you.
But I think
time.
And yes, you can read, and then we'll answer with you.
Perfect. The first question is, and if anyone else has any questions, please put it in the chat, and I can just read it out to Valentine and Isabella. The first question is, can NGOs provide amicus briefs to cases before the Kenyan courts?
Nyokapi, please.
So thanks, Isabella, for that very useful overview. Every time I hear from you, I also learn something new today. I have. So yes, NGOs can provide amicus briefs to any court. I do know it happens at ECOWAS, and I'm also aware that it happens in Kenyan courts. Broadly speaking, what the organization would have to prove is that you've got expertise in whatever field. So for example, if it's a question or an issue arising on violence against women, you just sort of tell the court what expertise you have. Of course, amicus interventions are intended to be neutral. So what you'd be doing is that you'd be providing information to the court, but not necessarily supporting one party over another. And just a note here that interest, an NGO having an interest in a matter does not necessarily mean that the NGO will then be partisan. So at least Kenyan courts have really been able to tease that difference and say that even if the information that's being provided may look sort of biased to one party, that does not necessarily mean that the intervention itself is partisan. So it's just a question of interest, and then you're just sort of telling the court that this information will assist you in the public interest, make an intervention, or rather make a decision that is just that would protect the right. So yes, and it's something that we highly encourage. And one of the ways that NGOs, especially NGOs that work outside Kenya, have tried to do it is that they come together they partner with an NGO working within Kenya. So that's how it happens in a lot of the litigation I've been involved in, where an NGO can have an interest in a matter, and then they approach the person who's doing the litigation so that they can partner and see how they can do an amicus intervention that can then be supported by the court. That way, it deals with issues of standing, which within our courts can be a bit problematic. Yes. Should I just run through the questions, or does... Okay, so what can NGOs do together to enforce judgments relating to violations of the protocol? So I think what Isabella has mentioned, the scorecard is one step. It's something that I know is still sort of nascent, and it's still sort of being done, and that's at state level. But NGOs have a unique position because many NGOs have observer status with the Commission, and getting it is fairly let me say fairly simple, because usually it's just an application, and NGOs can put both shadow reports or put in their own reports. So even during the convenings of the Commission. So it's one of the ways. It does tend to be a bit soft law, but that at the regional level, that's one of the ways. Broadly speaking, at domestic level also, as long as the provisions are not contested, there are no reservations, then at least in Kenya or in many other countries where the question of dualism or monism doesn't come in, then states are able to say that, or rather, parties can argue that these provisions of the protocol are as binding as they are like any other law. I know this is the case in many Francophone countries. In Kenya as well, the Maputo Protocol, with the exception of the provisions that where Kenya has actually expressly reserved, are actually binding. So the state obligations that are found within the protocol are actually binding. What we do as lawyers is just to try and be a bit more careful, is also situate those obligations within also our Kenyan law. So for example, we'll talk about the prohibition on discrimination within the protocol, but also talk about it also within our domestic constitution, as well as our other equality provisions in the law. That way, even when the court is making a finding, it does make the finding based on the Maputo Protocol, where the state is actually obliged, but over and above that, the protections afforded to individuals under domestic law. Okay. Yes. So in terms of reviewing and monitoring the scoring of states for the scorecard, as far as I know, and Isabella, you can correct me, this is usually done at state level, where states are the ones to come and report. One of the ways that we can ensure that our states are providing accurate reports is to participate in the reporting process that is already there for NGOs, as well as in it's called the Commission of State Parties, the review process that usually happens once a year at that level. That's one of the ways to be able to do that. Unfortunately, of course, the protocol, right, the AU right now is taking the language of AFTA and trade and peace and political, but in terms of women's rights, I mean, I think it's something that we have a great opportunity that we need to explore a little more on. I'll just pause there in case Isabella wants to add something on that one.
Thank you very much. Yes, so we also, during the African Commission, just prior, on the sidelines of the Commission, just before, we usually have there's usually an NGO forum that happens for 2 days, where we then are able to talk about the situation of Africa collectively, and we prepare a joint communique that is presented during the Commission. And this is also some of the ways that we are able then to hold different states accountable, because what appears during the communique will be part of the agenda for the Commission at some point within the 10 days that the Commission takes place. In terms of this scorecard, what we are trying to see, the AU has not made it yet public, but we are hoping that this is a scorecard that's going to be
Valentine, can you hear Isabella?
I can't. I wasn't sure if it was just me.
Isabella,
did I?
Yes, we lost you from
public. Sorry,
from public when you were talking about in terms of the scorecard.
Oh, I was saying that, did you get where I was saying the NGO forum?
Yes, we heard about the NGO forum that comes just before the sitting of the Commission.
Yes.
Like
So
what you
thereafter, we prepare a communique that is presented to the commission, and most of the agenda that we usually present is always discussed during the commission. Another way that we also trying to make sure we are part or participating or aware of the scorecard is AU is supposed to make this information public information, where you can then be able to go and look at the shadow report that was done by the NGO or human rights bodies vis-a-vis the state's report, and be able to pick out some of the inconsistency, because we know everyone, there are some sections where we never align. And so this is also part of the way in which you can be able to keep up, and they do have a mechanism of you being able to say what is in the scorecard that is not the true reflection of what is the reality. Thank you.
So yes, usually to participate in the NGO forum, all you need to do is register ahead of time. So I think it's still, like for example, the coming session, I'm not sure if registration has closed, but I know it's going to be, I think, from next week. It's closed, yeah. So I think, but it usually opens just for a short window, unfortunately. But in any NGO is actually eligible to attend and contribute to the communique. It's not just something that's only legal. Of course, sometimes the intervention can seem legal because of the nature of the documentation that we're dealing with. But in terms of also the shadow reports don't necessarily have to be written only by lawyers. So there is ample opportunity for everybody, all human rights defenders, to participate.
And if I might just add, if you'd want something to, because one of the things why we go to the commission, organizations like where Nyokabi works and where I work, because of the fact that we have an observer status, we are able to present, we are given about 5 to 8 minutes to present a statement on the status. So if you're able then to recognize organizations that have an observer status and have locals to be able to stand before the commission, you can jointly develop a statement to reflect some of the issues. So for example, if it's issues of SRHR, you can link up with Nyokabi. If it's issues around gender-based violence, you can come to CRU and very many other organizations within the country to then be able to do a joint statement and also participate in some of the segments.
So in terms of how judges are responding, I'd say it's a mixed bag. I think all judges do acknowledge, of course, that the Maputo Protocol is a binding instrument in Kenya, and that's not in dispute. I do know of a case where the court actually said that the obligations therein are binding, and the court actually elaborated why, despite the fact that which the protocol, so to speak. So we don't have an act domesticating the protocol, but because we are a signatory and in line with the Vienna Convention on Laws and Treaties, that the Maputo Protocol is actually binding on us because we are a member of the African Union. Now, in terms of content, so that's where there's a bit of contestation, like Isabella mentioned. We do have a lot of litigation on abortion that's going on now around access to safe abortion. We had a case a couple of years back, which is now presently on appeal, where the court, an expanded bench of 5 judges, said that in instances where a woman or a girl had undergone sexual violence and a pregnancy had intended, then that person was actually entitled to a safe procedure at government cost. And then what the court did is that it just said, for example, like in the protocol on the rights of African women, and then it went on to say, but Kenya has a reservation on Article 14.2 of the Maputo Protocol. So one of the grounds of appeal is actually that the courts were swayed by a non-binding provision. But for me, what that shows me is that in some instances, the court will borrow language of the protocol, even saying that, yes, even if that is then, it's not binding to us, but it can sort of situate our rights agenda within the language of the protocol, which is something extremely useful, especially where domestic laws are silent. The courts have also been quite receptive in property rights cases. Unfortunately, so the Maputo Protocol has this article, Article 7, which talks about the right of property for women in various forms of marriages. And in some of the litigation I've been involved in, we've been trying to get the courts to apply General Comment number 6 on Article 7D, which talks about the equality provisions and what equitable distribution of property for African women could look like, bearing in mind the peculiarities of the realities of African women. Unfortunately, the court will accept that as a binding instrument, but sort of has fudged the findings. So we are not quite there yet, but we are seeing that courts are quite receptive. When there was a lot of litigation around the practice of widow inheritance, even before our present constitution, which outlaws harmful cultural practices, judges would actually look to both to the Maputo Protocol and to SEDO, but specifically to the Maputo Protocol to talk about why some harmful cultural practices were unlawful. So the Maputo Protocol does continue to offer us promise in terms of what kind of one, the language, and then secondly, by just extending the protections that are found in the protocol to bring them down to domestic level, which we have found to be quite useful. So I don't see another question. Should I go to the other ones on the list? Or maybe we can open it up.
I will just type in a few questions into the chat now. And if anyone else has questions for Valentine or Isabella, please put it into the chat. Okay.
Yes. So this is a good question, Lara. I think in cases involving sexual and gender-based violence, because of the highly layered, highly sensitive nature of such litigation, states are not necessarily looking at the right to remedy properly. In the cases that we are presently developing, one of which we're actually developing with Isabella, what we are trying to do is to use the language of the Commission, for example, in the NIAMI guidelines. So like she mentioned, we not only have the protocol, but the Commission has actually interpreted some of its provisions and talking about what the right to remedy should look like. So for example, the law, our domestic law just talks about punishment of the perpetrator, which is one of the ways that the victim can find remedy. But from the Commission documents and the language of Articles 2, 3, and 4 of the Maputo Protocol, which prohibit violence, discrimination, and all forms of cruel, degrading, inhuman treatment, we know that remedy is actually supposed to be for the victim, and not necessarily to punish the perpetrator, but also to ensure that the victim is returned to a sense of normalcy, and they sort of like there is retribution in the sense that they get back what they have lost, to the extent that that is possible. So we've been drawing a lot on the NIAMI guidelines. This is still work in progress. We want to see how the courts are going to respond to it. But in the case that Isabella mentioned, where the court made a finding around Article 4 of the Maputo Protocol, that's what the court based to talk about the right to remedy. And it says that the state, because it refused, this was in the context of post-election violence, that because the police refused to protect these women who were in high areas that were prone to violence, where they live in that area, it was very volatile in terms of electoral violence, the police ought to have known, because everybody else did know. So the police ought to have taken certain steps. And that's how it sort of situated the right to remedy, now to give the money compensation, monetary compensation to these particular victims. But what we are trying to do in our case is to look at what goes beyond that. And here we're thinking about rehabilitation, we're thinking about even as simple as medical treatment, to sort of extend that based on what the Commission has said in the NIAMI guidelines. That's the, I'm forgetting its full name, I'll type it out once I get it. The NIAMI guidelines. So I'll get the full name and then type it out for you. But basically the guidelines for the states in how they're supposed to respond effectively to sexual and gender-based violence. So one, yes, there should be a negative consequence for the perpetrator, but the state must also do everything that it can to act with due diligence to ensure that the victim is not continuing to suffer based on the act of violence or the continuing effects of the violence that they may have on them. So I'm gonna just put it that. So and here, one of the things that I really like about those guidelines is looking at access to justice, not just as access to a courtroom, because we do also know that there are many victims of SGBV who choose not to report, like in a police station, or they may choose not to go through the court system. And having a framework where they can access a remedy without necessarily being subjected to this, re-victimized by what can be often a very violent justice system. That for me is quite transformative. Kenya has tried in this regard, and I know it is in compliance with the obligations under the Maputo Protocol. We have a Victim Protection Act that does not require you to have initiated a criminal case, but like I said, a lot of this work is something that it's still nascent, and we're still sort of testing the law to see how this would look like, to see whether there's full realization. So we're hoping that this case that we're going to develop with Isabella will extend this a bit further. In the case of the Dorothy, this is the Njamena case. They were given various remedies, including, so there was, of course, the remedy provided to herself, but one of the things that's particularly transformative in this case is that police officers were supposed to have been trained on how to respond to violence and how to deal with claims of sexual violence.
Isabella, can I add? Okay, let me just so yes, some of the interesting. So this actually, I'll just read them out. Some of the orders or rather effective remedies. So there was an order for the enactment of a law eliminating all forms of violence. There was an order for the adoption of other legislative, social, and economic resources such may be necessary to ensure that protection, punishment, and eradication of all forms of discrimination against women. An order for the provision of support services for victims of violence against women, including legal. An order of the establishment of a mechanism or procedures for the protection of women, such as shelters, reporting, education about it, creation of awareness. And then there was also an order for the development and wide implementation of awareness raising education and communication strategies. So based on this, you can see that they went over and beyond just the usual monetary compensation to actually look into what are these issues that are, what are the systemic and structural barriers that continue to exacerbate SGBV beyond just making sure your client is paid? What else can you be able to ensure the state institutes that would lead to a more sustainable solution towards gender equality? Thank you.
So I think the next question is how do we enforce such orders? Of course, it's really, really an uphill task. I think it's one of the things that we're really thinking through. So it now goes back now to advocacy, because we've gotten the win in the courtroom, but then we have to work with government. The organization that I work with has had some success in this, because we managed to work with government to develop an isolation policy that was in relation to tuberculosis, where people who are not adherent to medication for one reason or another would be placed in prison, and we're able to demonstrate to court that this was it wasn't the least restrictive means of ensuring that patients were adherent to medication. So we worked with the ministry and were able to get remedies. What has been the learning lesson based on that litigation, and also as we design our women's rights work, is the importance of having asking the court for orders that are structural in nature. So in as much as we ask for transformative remedies or remedies that go beyond, like for example, if you want government to ensure that they implement something, but you sort of need to ask the court also to ask for a report back mechanism. What we call it a structural interdict in this part of the world. I think it's even around Canada, that's what it's called. So when we get the order, we have to keep reporting back to court about the progress of the order, of how far has government gone in terms of complying. So as long as there's no appeal, that's usually fairly easy to do. And usually now in cases for relating to women's rights, we do see that that's one of the ways to go. Yeah, something I think that Isabella forgot to mention in the crew matter, or rather, what I can add to that is that that's part of what the court ordered, that if the parliament fails to comply with the representation rule, then parliament should start, the CJ should make a recommendation to president to dissolve parliament. And eventually that's what was done. So for me, parliament was not dissolved, but it was a significant win because the CJ actually said, look, you can't have 3 judgments telling you that you need to comply with the directive to ensure that parliament is representative of the population in terms of having a third representation of women, and you fail to. So the CJ actually wrote to president and said, parliament has failed to comply, therefore dissolve parliament. The day that happened, I remember there was a lot of halabaloo. And in this current sitting, the current parliament, which I think is the 11th parliament, is actually a little bit more representative than it was before, because political parties, everyone is afraid of losing their political seat. It's some sort of pressure. So just the fact that you can make that step, it sort of helps us address some of this impunity. It's not a silver bullet, but these incremental steps are what we are looking for, because prior to, that was I think last year, but prior to 2021, I don't think there was any question that anybody could dissolve parliament under our current constitution. So the fact that it is because of that women question, for us, that has been something significant. We now know actually our current president is actually taking steps to ensure that there's political representation in line with the Maputo Protocol and the constitution. So in terms of how you design such orders, it really depends on each case. I have a current case where what we've done is we've said, because it involves women living with HIV, and what we've asked is that the women be involved in designing a long-term strategy to ensure access to medication. So a lot of times you have to work with the movement to see what's feasible, and also now based on the legal knowledge, we see what is feasible. Sometimes you can ask for 90 days. You actually write it as one of the orders that you're seeking from court. So you pray, apart from the declaratory reliefs and the orders for compensation, you're actually asking for that the court issue an order requiring that the respondents report back to court or file affidavits in court within 90 days of this particular judgment being made. And therefore, it's actually a court order. The lawyers would be attending court as if the case is still ongoing. And for us, this particular remedy has been found to be useful, and it's a sound remedy all the way up to the Supreme Court, which said that the structural interdict is a good remedy that can be given in Kenyan courts. I'm aware it's also the same in South Africa. I know in several, actually other Southern African states. So it's something that we need to utilize a little more. So I think Isabella has the brief. I think we would welcome amicus interventions, would welcome interested party interventions, sometimes even just legal expertise, sometimes having an extra, what do you call it, an extra eye to look at pleadings. I think we'd be happy to do that. I'll leave Isabella to lead us in that intervention.
Yes, I think we are open to this, and when we are holding perhaps litigation surgeries, those interested perhaps can leave their names, and we'll be able to reach out to them and see where the interest lies, and also just keeping up just with what is happening. I think that would be useful for the organizations. Yeah. Thank you.
So in terms of how victims access remedies outside courts, for us, we try to look at it like from this 360 point of view. Of course, the most common is victims want to access remedies. They want somebody jailed. But sometimes a victim will come and tell you, I just want him to apologize to me. So we don't encourage mediation for sexual gender-based violence cases at all. It's actually something even within our sentencing guidelines that's not allowed. But sometimes the victim might need counseling, which is one of the ways that you can get. One of the things that we're also thinking through based on our victims protection and our witness protection legislation is to see whether we can get remedies not outside the criminal. So we have the criminal, but what we're trying to see is whether we can explore remedies in a civil case. So that in as much as somebody has gone to court, for example, where they have to continue getting certain kinds of treatment, to what extent can the perpetrator be compelled to pay? And there the standard is a little lower. There has been, again, this is a mixed bag. We have a case, the TSC case, we call it Astarico, where a teacher who had sexually assaulted two of his pupils was required to pay damages to them. So it's and not just him, also his employer, the Teacher Service Commission. So yes, I know the question is remedy outside court, but one of the things that we needed as, or rather the advocates, when you read the cases, it's an extremely interesting case. I believe also crew worked on it. But one of the things that really came out of that case is the obligation of an employer, when you know your employee is involved, is one, in a position of power to especially very young girls, and then exploits or abuses that position of power to abuse those his victims. What's that responsibility? And I am aware that the Teacher Service Commission has then been required to take a policy around dismissal of teachers who have been involved in, or even, they go through the disciplinary process, but they're not just transferred, they are actually dismissed from service so that the threat is out. So that can be one of the remedies in terms of it's a guarantee of non-repetition, at least in that particular instance.
And the other thing that for us, when your is talking about transformative remedies, is in this particular case with the TSC, they did need to put a policy. In fact, they did a memo, a circular on teacher to pupil relation, sexual relation, just to cover themselves in terms of saying, look, we are now telling our teachers this shouldn't be happening. And in the event that this does happen, TSC has done its part to ensure that it's very clear. So there's a circular that is still the document that we utilize when we are usually, when we handle matters of defilement between a teacher and a pupil or a student. So those are part of the remedy, like, for sure they'll be covered.
So the next one is, what is the law that gives power to courts to make a structural order? So courts have inherent power to ensure that the orders that they are giving are not in vain. So they have powers to ensure that happens. And in the Supreme Court, this case, it's called the Me Too Bell case. In case any Kenyans here, but I can share it with I can share it on the comment box as well. And one of the things that the court was saying is that courts have actually power to make sure that whatever orders they give, they are actually complied with. And therefore, and as a component of the right to remedy, therefore courts must ensure that their orders are not in vain. So it doesn't need to be necessarily written in a law. I remember part of government's argument in that case was that once a court downs its tools in terms of its written its judgment, that its role ends there. But what the court was saying is that that's not necessarily true, because the court is supposed to give meaningful and effective redress to people whose rights are violated. And if that requires then the making of a structural order, then the court is well within its rights to do that, and parties must therefore comply with those orders. So we actually don't have it written in a law. Our constitution is sort of broadly framed, and now courts have read into those into the remedies provisions in our Article 23 of the Constitution to say that courts can make any order as long as those orders they stem from the dispute before the court, and thereafter they can therefore ensure that there's implementation of the law, or implementation of the court's orders. In terms of deceased parents, victims having right to reparations, yes, they do. Of course, they would have to go through the process of getting the representation of the estate of the deceased person. So if it's a child, for example, the parent can actually now just apply to, representing the estate, but also as a parent. And what then happens is that the parent now would be bringing the evidence to show how the state feel in its obligation that now therefore led to the death of the victim. There is a famous case, we call it the JMM case, the one I had mentioned previously, which is on appeal, where they talked about Article 14 of the Maputo Protocol. That case involved the victim, the JMM, who has been anonymized to protect her safety and her dignity. When the case started, she was alive, but she died in the course of the proceedings. But the court, the mother went and got a grant of representation for her, and the court found that it was proper because the violations were suffered. So the mother was able to continue with the litigation in her name as well as in the JMM's estate's name. And part of the orders that were being given were actually to say that it's the government's actions that actually made JMM die, because they refused to offer her a safe and legal procedure, yet she was a victim of violence. Yes, I can send you these resources in the cases. I'm happy to do that. I'll share them with Isabella, and cases were repeatedly. Yeah, I think cases where economic violence is involved are extremely difficult. What we try to do in Kenya, and this relates, I think, to another question I saw in the list of questions that had been shared with us earlier, is because sometimes women will go back to a violent situation because they feel like they have no other choice. Unfortunately, because we are also resource scarce, the state has not been properly addressing the economic needs of victims of violence, particularly in domestic situations or in private spaces. Yet there is still an obligation to do that. So just acknowledging that there's an extreme gap there. I see it as a way, maybe it's one of the things that we could actually pursue strategic litigation on, because when women are forced to go back to violent spaces because of financial issues, it's because that abuse has been continuing even in the context of that relationship. One of the things that I know Kenya has done, which in theory, it works beautifully in theory, not so much in practice, is that we've got a Prevention of Domestic Violence Act, which provides for civil remedies. So you can actually go to court, sue the person sue your husband, so that he doesn't touch you, he doesn't beat you, but you actually stay with him. So you sort of have this piece of paper that provides you with protection, so to speak, so that if he beats you, you can go back to court. I used it once a long time ago. That was actually even before the PDV, because what we did was that we went, I was a young lawyer, then what we just wanted was this guy to sign a bond to keep the peace. And he did, and he was very scared. But we know that in the context of a private relationship, the police are so reluctant to intervene. But we see this as a failure of the state due diligence obligation to protect women and to prevent violence. So I think there's a potential for litigation there. There's definitely potential for advocacy. The organization I work with really tries to do advocacy around this, trying to do social norms training, why men shouldn't be there, women, so that even if you're not going to give them money, but also don't beat them. It's hard. I don't have a proper answer to this question, unfortunately. I'm just sharing my experience. It's one of the ways that maybe we can think about seeing how we can use the domestic violence processes to try and protect women if they choose to go back to what could potentially be a violent situation. Isabella, you wanted to add something?
Yes, I wanted to add, when you do the spectrum of due diligence, the 5 Ps, protect, prevent, if you can actually be able to assess to the degree in which the state contributed or is contributing to normalizing perpetrators being able to negotiate with their victims for purposes of dependency. And so you should be able to say, look, the state has not put in shelters that then would allow us to be able to provide this for these women. It doesn't have we have a Social Protection Act. How is that executed in circumstances like this, where a woman in that predicament or a victim in that predicament will need or will require some level of cushioning? So there's definitely a lot of potential, but then it would mean that we would need minds to literally sit and critically analyze the various facets and circumstances, because the thing about due diligence is the state always comes and states, or rather says, we have done what we can based on the resources that we have. And so those are some of the things, even as we're thinking about due diligence matters, we should be able to interrogate further. Thank you.
Yeah, that's actually very true, because they come and say, we've done what we can. And then on top of that, they'll say, but this person returned themselves, returned themselves. And we definitely need to think about it. The NAMI guidelines actually talk about provision of shelters and psychosocial support to enable women break away from the cycle of abuse as one of the obligations of the state. So I think we sort of need to explore that a little further. Non-compliance of court orders. I can assure my colleague from Nigeria that this is a Kenyan problem as well. What we are now learning is that, like I said, the judgment does not, the judgment is not the win. The win is what happens after the judgment. I think that's where a lot of the work happens. One of the ways is, one, let's try the structural order, but a lot of it also has to do now with the advocacy that we are able to finance. To do. I know, at least in the Kenyan context, we have challenges around funding, because many funders will decide to stop at the point of the judgment. After all, you've gotten your judgment. But so now for us, the challenge has also been to try and ensure that we are able to sustain a case even beyond the judgment. So we are doing advocacy, we are writing about it, we are publicizing it as much as possible, especially for those of us who work in movements. We even go as far as developing infographics that we hand out for free within communities, so that people can be able to talk about judgments and say, look, the court has said. Just the way they will be able to say, oh, the Constitution says, they should be able to say the court has said. But this is a continuous process. And it really just goes back to a human rights-based approach that involves both building the capacities of rights holders to be able to claim their rights, but at the same time trying to push governments as duty bearers to comply with their obligations. I think maybe beyond that, we can also try and exploit there's shame factor when a whole minister goes to make a statement at the African Commission, but NGOs are there saying, no, you haven't done this. For us, the shadow reporting mechanism has been extremely useful. For example, I remember when before even conversations around widow inheritance being a violation of rights of women, it used to feature a lot in concluding observations around the world and even for Kenya. So those sort of harmful cultural practices, and that's been useful because it also now sort of links back to any other case you might choose to do. So it's a mesh of all of them. So for the lawyers, we must continue to ensure that court orders are complied with, as frustrating as it is. But sometimes, it's piecemeal, but it does happen. But leveraging on the movements that we work with, and leveraging also on regional spaces or international spaces where our governments really like to go and showboat. So I don't see any other questions, Isabella or Lara?
That is all the questions. Let me just check. Okay. I think that is all so far. If anyone has any more questions, you can send it over to me, and we can plan a session to do a one-on-one to answer any further questions. Yeah, I will just paste SAHR's social media handles into the comments section for everyone to access as well. Okay. Well, thank you so much, Valentine and Isabella, for presenting and answering all these questions and sharing your expertise with us. It's so helpful, and I learned a lot from you both today. And thank you everyone for being a part of this workshop on integrating and using Maputo Protocol in your legal practice and advocacy efforts. It's been great to connect with like-minded individuals who are passionate about women's rights and gender equality. And yeah, thank you again, Isabella and Valentine, for taking time today and sharing your knowledge with us. So just to say one more time, if anyone needs a follow-up, we can arrange to do so if necessary. And I'm just going to paste a link just for an evaluation of today's workshop. If everyone has the time to do so, that would be great. Thank you.
Thank you very much, Lara, and thanks for everyone who joined and participated. It was indeed a good exercise for Nyakabi and I to remind ourselves about this protocol as well. Nyakabi?
Thanks so much for having us, colleagues. It's also been very interesting to listen to your questions, to respond, to see do we really know everything. It's really also it's a learning opportunity for us as well. And thank you so much for having us and for gracing us with your time. Feel free to get in touch in case you need anything further, and in case you need any future collaborations. I think you both now have my email, so feel free to reach out. And I'll also follow you on social media.
Thank you.
Thank you. Good evening, good morning.
Yes, enjoy the rest of your day, morning, evening.
You
Goodbye.
too. Talk to you soon.
Bye-bye.